Good morning. My name is Ellen McDowell, and I own and manage McDowell Law PC. It's April 3rd, 2020, and our country and our state are in the midst of a severe financial and health crisis. Small businesses all over the nation are struggling and worried sick about whether they're going to be able to survive once this crisis is over. I understand that my business is a small business. We have 15 employees, and I'm doing everything I can to keep them employed and keep their wages paid so that they can pay their bills. I also have lots of small business clients, and I know from talking to them that they're also worried that when this crisis is over, they don't know whether they're going to be able to keep their businesses afloat. Some people are going to have to file bankruptcies. There's a small glimmer of hope because in 2019, Congress passed a law that changes the bankruptcy code that allows small businesses to reorganize much more efficiently. It allows them to reorganize quickly and with a lot less cost than was previously required. We have several lawyers here who understand, who know the law, who are ready to help. I am attaching here a video that was made by our own Braverman, a certified bankruptcy attorney, both commercial and consumer, who is extremely knowledgeable about this law, has presented at seminars, and will explain it to you so that you can get a little bit of an understanding about the help that's out there. If you need us, we are here. Call us anytime. The number's on our website. Email me. I'm ready to help. We're going to be here. We're going to make it through this. God bless you all.
Today we're here to talk about some big changes made relating to small business bankruptcies. Filing a bankruptcy for a small business has been problematic for a long time. Chapter 11, while it's helpful in reorganizing debt, there are a lot of requirements to proceed with a Chapter 11. Sometimes they were so burdensome for small businesses that the process itself made it difficult to succeed. Congress attempted to fix this problem on several occasions. In 1994, they passed a small business bankruptcy law. The idea was to streamline bankruptcy, but the end effect of it was it made it a little easier, but not enough to make a difference. You could get a conditional approval of a disclosure statement. Some of the time frames were shortened, but in the end, it didn't really fix the major problems. In 2005, Congress again attempted to fix the problems with a new law. They again failed. The new law would require additional documentation for debtors to provide. It required more oversight by the U.S. Trustee's Office. So in the end, it really wasn't much better than the 94 law, and it was not successful. In 2019, a new small business law was passed, went into effect February of 2020, and this is much more effective as to accomplishing its goal, which is to make small business bankruptcy more affordable for small businesses. There are several important components. One, there is no creditors committee. So creditors committee makes a Chapter 11 debtor come up with more money, generally makes it more difficult to have a successful plan. And a small business already struggling cannot afford sometimes those additional amounts that result from dealings with the creditors committee. There's no voting per se, so they're still voting, but even if the creditors vote against the plan, as long as you're paying at least the value of the assets and at least your disposable income, you still can get your plan approved over the objections of the creditors. There's a trustee appointed in the Chapter 11. It's subchapter 5 of Chapter 11 is what this new law is referred to as. In any event, there's a trustee appointed, which is different than the trustees in a Chapter 13 or even in a Chapter 11. In a Chapter 11, if a debtor doesn't do what they're supposed to do or the management doesn't do what they're supposed to do, then the court can appoint a trustee in the bankruptcy, in order to oversee the case and basically take over the operations to a large degree. The trustee in the subchapter 5 of chapter 11, their goal was to try and help the debtor get a confirmed plan. They can contact creditors, they can make suggestions to the debtor. So their goal is to work with the debtor to get the plan accomplished. There are no quarterly fees. That can be a big expense in a Chapter 11. Again, a struggling small business can't afford these extra expenses. That's no longer a requirement. The plan is more streamlined, more similar to a Chapter 13 5-year plan. You can also pay administrative costs, at least to some degree, over time. In a normal Chapter 11 that has to be paid upon confirmation, that can be a burden. So while there are still some issues with the new law, Congress has done a good job in actually addressing a lot of the problems that exist for a small business in a typical Chapter 11 case.